Thank you. My name is Tom Dunn. I'm an attorney at the law firm of Pierce Atwood in Massachusetts and Rhode Island. I'm also the president of the Tufts Lawyers Association, TLA for short. I graduated from Tufts in 2000 and welcome and thank you all for attending tonight's program with the Honorable Nancy Atlas, a 1971 graduate from Tufts. Just briefly, Tufts Lawyers Association is a 501c3 nonprofit formed nearly 20 years ago. Our members are people who graduated from Tufts and also graduated from law school. We aim to foster a network for educational mentorship, business development, public interest purposes to support legal education. A few months ago, we started this Tufts Judicial Series to honor our TLA members who have joined the judiciary. This is our fourth program in the series. If you're interested in watching the prior sessions, visit Tufts website at tuftslawyers.blogspot.com or the Tufts alumni YouTube page. As you'll see on our webpage, we're an active organization. We have branch offices, branch groups, different communities around the country, one in New York, one in DC, one in California. Don't have one in Texas quite yet, hoping to expand as much as we can. We have a variety of ways to connect with us through social media. You search Tufts Lawyers on social media, you should find us. We have an opt-in directory with over 175 TLA members and various other ventures. We have two programs coming up in the recent weeks ahead. On May 25th, we have a Business Development 101 program for attorneys. Amy's going to put in the chat room the registration links for that. And on June 2nd, we're featuring the Honorable Stephen Locke, U.S. Magistrate Judge from the Eastern District of New York, who's also on this call right now. So we hope to see you there as well. As far as tonight's program, we have two co-moderators that are going to lead the discussion with Judge Atlas. And I'll briefly introduce both of them and Judge Atlas. They will do their Q&A for about 40 minutes, 45 minutes. And then at the end of the program, we may have some open Q&A or may break out in smaller groups, depending on how we determine at the end. First, I want to have you meet Jimmy Leo. He is the Assistant United States Attorney for the Southern District of Texas Criminal Division based in Houston. He's a 1994 Tufts graduate. Following his time at law school at Dickinson School of Law, he served as the Assistant District Attorney for the Hidalgo County District Attorney's Office. He's been at AUSA since 2005, serving in both criminal and appellate divisions with the United States Attorney's Office. Second, we have Laurens Wilkes, a 2002 graduate from Tufts. He's a partner at the law firm of Jones Day's Houston office. His practice focuses on complex commercial litigation and construction law. Prior to joining Jones Day, Laurens graduated from the University of Texas at Austin and clerked for the Honorable Ron Clark, U.S. District Court of the Eastern District of Texas. And finally, I have the pleasure to introduce our featured guest, Judge Nancy Atlas. Judge Atlas graduated from Tufts in 1971 with majors in mathematics and political science. She went to the NY School of Law, where she was the managing editor of the 1973-1974 Annual Survey of American Law. Judge Atlas clerked for the United States District Court for the Southern District of New York, served as an AUSA for that district, and then later handled complex commercial litigation matters in both New York and in Texas. In 1995, she was nominated by President Bill Clinton and appointed to the bench. And during her time on the bench, she served and continues to serve in a variety of leadership positions for her court and for bar associations, including the ABA section of litigation. Welcome, Judge Atlas, and thank you, Jimmy and Laurens, for moderating. If you have any questions that you would like to submit to Judge Atlas, please put them in the chat room. I will be monitoring that and may pop in with a question during the program. Jimmy, Laurens, take it away.
Thank you, Tom, and thank you everyone for joining. As Tom just mentioned, we do want to make this as interactive as possible. So if you do have any questions, please raise your hand, put them in the chat, and we'll make sure to go over them. Now, Judge Atlas, can you tell us just a little bit about the path of how you went from Tufts to becoming a judge?
Well, it's over 50 years. So I became a lawyer, I practiced law, and then I moved to Texas and practiced law some more. And then somehow lightning struck and I got to be selected as a federal district judge. In fact, the selection process is like lightning struck, I mentioned. I had no idea I would ever be a judge until my last year of college. I graduated in 3.5 years, but until my last semester, I had no idea I even wanted to be a lawyer. I was a math major and thought I was going to go work for IBM, have a job for the rest of my life doing computing. But I went to law school. The onslaught, if you will, an increase in number of women in law increased because in part women applied to law school when the deferment for the Vietnam War ended for law students and lawyers. Anyway, I went to law school, did pretty well. I wound up working during law school for the U.S. Attorney's Office, and I got a feel for federal litigation, criminal litigation, et cetera. I did not want to put people behind bars, and so I did not apply to the United States Attorney's Office, despite being urged to do so after my clerkship. That's, of course, very ironic, but because now as a judge, I make those decisions. But fast forward, I met a guy and moved to Texas, and one thing led to another. I became a partner at a law firm. I had kids. I was trying to actually work part-time, but I wound up getting involved in political fundraising and working in a volunteer position for the state of Texas, the Higher Education Coordinating Board. And through that and my mediation practice and some large litigation where I represented parties, I got to know lawyers on both sides of the fence, plaintiff, defense, Democrat, Republican. I was a fundraiser for Democratic causes, Senator Benson, Ann Richards, the like. Anyway, when Bill Clinton got elected, people approached me about applying for the judgeship. I was shocked, truly shocked. It never had occurred to me. But the more people talked about it, and frankly, the more I thought about being in the role of a neutral, the more I decided I would try, I would go for it. And I did not get it the first time I applied. 2 other people were chosen for the 2 slots that were then available. But fast forward 2 years, the Senate flipped from being Democratic under Bill Clinton in the midterm elections to Republican. One of my patrons, Senator Benson, had taken the job as the Secretary of Treasury. And so he was not in position to promote me. Jack Brooks, who was the senior person in the Democratic Party from Texas, had another candidate in mind, but that fellow's nomination failed. And Jack Brooks lost the election in 1994. So the White House called me and asked me to apply, and I was able to get my other ducks in a row. And I applied, and 6 months later, I was confirmed as a judge. So it was a whirlwind. In my book, you cannot graduate from law school saying, I want to be a judge. I mean, you can say it, but it is the goal is to be a well-respected lawyer who is an honest broker of positions and doesn't have sharp practices, so you don't have enemies that wind up in high places. So anyway, that's how I got to be a judge, and it really was a miracle.
Hi, Judge Atlas. How you doing?
How are you, Jimmy?
I'm doing well, thanks. For those attending, I've appeared before Judge Atlas numerous times, so we do know each other. Judge Atlas, you spoke a little bit about your time at the U.S. Attorney's Office. I think it was in New York, right? The Eastern District?
Southern.
Southern, sorry, the District of New York, I think they call it.
Right, we were in the office. Sorry, Judge Locke.
So, how would you say that impacted or influenced, or did it affect you in any way in terms of being a judge? Because as a judge, I know you did mostly civil litigation. So did it prepare you at all for the criminal side of cases as well?
Yes, in law school, I worked very hard my first semester and thought I would drive myself crazy. So I networked with a couple of lawyers I knew, and I wanted to try to work for the U.S. Attorney's Office. And I got into the Southern District of New York as an intern in the second semester of my first year. And I got a fellowship that flowed from that from NYU to serve full time in the summer. That was all in the criminal division. In fact, I worked with, believe it or not, Rudy Giuliani, Howard Wilson, Mike Mukasey, a bunch of very, very well-respected criminal prosecutors. And they allowed me to do research and, obviously document review and prep. And because I worked there almost full time for a year, I wound up seeing a lot of criminal work. Then I clerked for 2 years, and my judge did have me in court for all of his criminal and civil proceedings. So I saw a lot. I honestly didn't, back then there were no sentencing guidelines. So I didn't want to go to the office as a career prosecutor in the 70s. Because when a sentence is 0 to 20 or 5 to 40 years, I didn't want to stand up in court and ask to put people behind bars for that reason, even if they'd done the crime. It just wasn't in my constitution. But by the time I got to the Texas and the judgeship application, there were sentencing guidelines. So there were structures, there were factors, there were tests that you had to apply to somehow equalize cases, or at least have them rationally measured against one another. Those guidelines had their strengths and weaknesses, but the point is I had the tools I needed to sentence. And frankly, then I was making the decision based on a lot of information. So I had grown up, and I knew that prosecutors had a lot of discretion and a lot more information than I had perceived as a law clerk. There's no question, even in the civil division, I did RICO prosecutions on the civil side. I went to the U.S. Attorney's Office, and I was qualified for the criminal division, but I didn't want to wait a year to get in, and had all the sentencing issues. And so I thought, I'll do criminal. And Bob Fisk, who's an icon of a lawyer and a U.S. attorney, agreed to let me do affirmative litigation in the civil division. So cases that couldn't be made criminally, I didn't get to see the grand jury stuff or any of that, but they would just hand cases over to the civil division. A couple of us did our own investigations and brought the first RICO cases. And so having some criminal experience did give me a lot of benefit from the perspective of judging and the perspective of litigation, because you had the burden of proof as a prosecutor. Does that answer your question?
It does. Thank you, Judge.
Judge, what are some of the biggest changes in the profession that you've seen from the time that you've been on the bench until now? What are some of the things you've seen, both practical, but also just in terms of changes in the law?
Okay, well, I've been on the bench almost 26 years, 25 and a half. when I started, there were computers in 1995 in our offices. Unlike when I clerked and when I was at the US Attorney's Office in the 70s into the early 80s, there were no computers back then. It's a much more interesting question when you compare what I was in the United States Attorney's Office in the Southern District of New York to where I wound up in court in the Southern District of Texas. But in terms of 25 years, we had paper files. We had, there were no handheld devices or very, I mean, nobody used them. The cell phones we had were not smartphones. So getting information, talking to clients and all that was completely different from what it is today. In court, there was a huge debate among the judges in each court about whether to have Wi-Fi in courtrooms. And I do believe that there are still courtrooms that do not have Wi-Fi. The reason that Wi-Fi is a problem and the reason that smartphones and lawyer handheld devices or computers is a problem is there are no cameras in federal court in the courtrooms. We do, for what it's worth, have security cameras, but they don't have audio and they don't record for any length of time. But we have very sensitive cases, as Mr. Leo knows. We have very sensitive criminal cases and from time to time civil cases. And cameras are an intimidation to the witnesses and or security hazards. So we were very reluctant to bring in computerized devices and the like in the courtroom. Nowadays, you know, fast forward the last 5 or 10 years, the jury has screens, so the computers, all the lawyers come in with all their stuff. And we're now, of course, during COVID, doing video witness testimony when necessary. So it is a vast difference. The other thing is, substantively, you asked what's different. The laws were complicated, you know, discrimination laws and Fair Labor Standards law and patent. They were complicated when I started. And frankly, thank goodness I did have a civil background. Criminal, with due respect, is fascinating. It's like going to the movies. I love my criminal cases and the criminal lawyers. And frankly, I care enormously about what sentences and what happens to the defendants as well as the victim. But the civil is much more complicated. And we, thank goodness, have 2 law clerks. Some people even have 3 if they give up a secretary. But the point is, Congress passes laws they haven't read. They didn't used to do that. There used to be real debate in Congress, but now there are, 500-page statutes, and the legislators sometimes don't know what's in there, or they think they know, but then the words don't quite say what they anticipated. And so it's left to the judges to decide. Legislative history is unreliable. I think most of the judges we know, regardless of who appointed them, do not want to rely on legislative history because people dump stuff in the record and the reports are not endorsed by more than a few people, if any, if more than one. So they're very complicated statutes nowadays. Our law clerks generally work 1 year, and the law clerks, many judges hire law clerks, and we used to hire them straight out of law school. At one point, we were hiring people based on this was only 1 year, frankly, but based on their first semester grades. We were so eager to get those law clerks who were at the top of the class. And that was a huge mistake. The judges decided as a group, most of us decided we would wait and take the applications after the end of the second year and do it online through the system known as OSCAR. It's an acronym. So we had law clerks straight out of law school. But as a district judge that competes with the circuit for very smart law clerks, I need all the help I can get from top law schools. I found that it was better to hire people who had worked in law for a year, couple of years. So I was not always competing with the immediate graduates. I liked for the clerks to come from some experience in the law. And the law firms or the other institutions didn't really mind. They had the burden of training the law students for a year or two, but they definitely got the benefit when the law student came back from the one-year clerkship. And even if the law students or the lawyers went to a different firm, it all came out in a wash. So that was a big change. The other thing is that lawyers, there are some people who want to be career clerks, and more judges, because of the complexity and because of our volume and the increase in motion practice, which I guess is another big point to make, but many judges are hiring career clerks who become very experienced in federal litigation. And there are always new issues, but there is, I had a career clerk for about 2/3 of the time I was on the bench, and that enabled me to go to one-year clerks that I could train in the necessary amount of time. So those are some changes. I'm happy to answer more specific questions, but.
No, absolutely. That makes sense. Yeah, we, on our side, on the firm side, we have certainly seen an uptick in people going after being here for a couple of years into clerkships, which, like you said, I mean, works out great, I think, for everyone. So it is, but that never happened, 10, 15.
Never happened before, right.
So it's very interesting.
Yeah. The other thing is there is a push now to make the judges, of course, but also the court staff and law clerks more diverse. So I'm part of a program that the ABA started, the antitrust section started, and my husband, who chaired the litigation section, took over, and the litigation section has expanded it. It's called the Judicial Intern Opportunity Program, JIOP. And it is designed for law students from not the top schools. Law students are maybe the first in their family to go to college. People who are racially diverse or ethnically diverse, or who have come from different cultures in terms of the country or the communities they live in, who didn't have educated families, to get internships and be paid. And so the ABA does it now. The Federal Bar Association is doing it in Houston. There is there's a thing, Just the Beginning Foundation, judges of color have sponsored something like that. So we're trying, frankly, to get more diverse people into the clerkship realm and into the judiciary itself. That's a big change.
That was actually a perfect segue for me, Judge Atlas. I know you spent a lot of time serving as an active member of the American Bar Association, as well as being on the section of litigation. So kind of following that, what do you see as some of the biggest changes in the legal profession at this time?
I'm going to give my opinion, but I urge the people on this call to write to somebody, me or whoever, and give me their opinions on this, because I am co-chairing a task force for the section of litigation that is trying to figure out what the substantial new, the pressing, the most important legal challenges, the most important challenges are for litigators and lawyers today going forward. Now, having said that, I mean, we're talking, how do you handle technology from every which way? Cybersecurity. How do you understand what your clients do, how they maintain their documents? Those kinds of things from the technology standpoint are enormously complicated. And lawyers stand in front of me and say, I don't understand their system, or I don't really know how they did the search. I just asked the in-house counsel. Well, I got news for you. That's not good enough. And that is a huge change from lawyers taking responsibility years ago for the document searches that were done in the connection with discovery. This goes to the U.S. Attorney's Office and the partners you have on task forces in criminal cases as well. We as judges now, there is actually a push to say to the U.S. Attorney's Office and the assistants, you have Brady obligations. You must turn over anything you think is helpful to the defense. And I used to do that anyway. So to me, it's not new, but there's been an edict by the judiciary, and I think the U.S. Attorney's Office or the Department of Justice, to ask it on the record. But the whole point is, in terms of challenges, there's so much information out there. And I mentioned in my question to the crowd about technology, but there's funding of litigation. It's divided loyalties of lawyers between insurance companies and the insured. How do you keep up? I mean, yeah, there's the work-life balance thing, but that's been around a long time. So anyway, anybody who's got ideas about what the most pressing issues are you face from the perspective of practicing law, particularly as a litigator, I would love you to tell me. Just weigh in an email, and we'll give my email at the end. But anyway, Jimmy, back to your question. Lawyers today don't seem to think of law as a profession. They think of it as a business. And that's partly because of the complexities of practicing. Clients are, I think, being part of the ABA gives me, you know, I'm friends with tons of lawyers. And so I feel for the lawyers, because it's very difficult to be between a rock and a hard place. The judge is the rock and the clients are the hard place. They don't want to pay bills, or they're hiding things. I don't think that people think the oath is as sacrosanct as it used to be. I think that lawyers are very worried about their billings, to have them high enough to get recognized in their law firms, but the clients don't want to pay it. And so there's a whole problem. It used to be, when I started practicing, that law firms got paid a retainer by the month. And they use those lawyers however they saw fit. Sometimes they under requested, if you will, but other times they were way over. Lawyers worked a lot harder than the retainer would warrant, but it all came out in the wash, and people trusted each other because they just had a value billing sort of arrangement. Those lawyers that bill by the hour and they're billing $1,000 an hour, it's really hard to justify that. And I have friends at big firms. I mean, Laurens, I get it, but you have to be a darn good lawyer to be worth that. And when you don't, and some lawyers nowadays are hoarding the work. They're not sending it down and training the junior people. And they're not letting the junior people do pro bono, which gives the junior people experience standing up in court, winning some and losing some. So some of us judges have said, if you have a lawyer in your firm or in your organization with less than 7 years experience, and you have a pending motion, you can ask me for oral argument and I will give it to you, even though I wouldn't have otherwise done so. And do you know those oral arguments are usually better than the ones that, you know, with the highfalutin top dog. They're as good or better. And when we have cases where I've asked for argument, when that senior lawyer turns around and says to, you know, Mary sitting behind him, what was that case, or what was that? I say, you know, Mary, would you mind standing up and would you explain whatever the answer to my question? And I think Mary's had a heart attack, but on the other hand, she does it and she does it well. And a lot of lawyers, a lot of judges are saying to the lawyers, let the people who wrote the brief speak. Because we are worried as judges and senior people that the art of trying cases and the art of being an oral advocate and the art of the risk taking that is embedded in trials and contested hearings is being lost. Everybody wants to nail everything down at a great expense, and the clients second guess you if you didn't know something, but they don't want to pay for it. And that's a problem. So there are certain cost-cutting things that we're trying to do. The Duke project did, their new federal rules from 2015, the civil side. Anyway, the whole point is those kinds, it's really a problem. I feel for lawyers, the rock in a hard place.
Yeah, well, I mean, just to add on to that, you're 100% right. On the civil side, with so few cases ultimately going to trial, especially in federal court, what the judges have done in the Southern District here has really been fantastic. I mean, we have a bunch of associates have been able to take advantage of, like you said, making the arguments that wouldn't otherwise get an argument. And in fact, I think it's great for the client because anytime we can get in there and you can kind of express the views and you can get a dialogue going and you can hear what the judge, what's in your mind. It may not be at all what we thought the issue was. And have an opportunity to explain that, it's really a benefit to everyone. So I mean, we really do appreciate that. And I think that has been a fantastic piece of it.
You know, there's one thing that people should keep in mind, lawyers, everybody needs to make their own journey. The head of the Marshal Service taught me that when I was doing judicial security nationwide. And, you know, we would be scratching our heads when judges or congressmen were having problems with what we were doing, asking for whatever. And the point is, lawyers need to understand that judges have hundreds of cases, if not more. And we have criminal and civil. And of course, Laurens, you're in civil. And we prepare, we read, but we can't possibly know what you know. So some of our questions may be really dumb or ignorant in the context of the case, but we need to make our own journey. And so, and other times, it's not so dumb. Maybe the people who are really all embedded in it have lost the sight of the forest, you know, for the trees.
No, that's 100% right. I mean, and I guess just to say, I mean, one of the biggest pieces we're missing, and we're missing on the civility side that you kind of point out in all of this, is judgment, right? And in order to be able to develop some of that judgment, you've got to get some of the experience. And that helps you also, as your point of dealing with the clients.
That's right.
On the
and I will say this, if the clients didn't think the lawyer was after the last dollar, and if clients thought, like they used to, that the lawyers are professionals and have the client's best interests at heart, not the billable hour. And if the lawyer didn't oversell the case at the beginning, say, oh, I can win this. This is a piece of cake. Well, the lawyer at the beginning doesn't even know the facts. I mean, really? But anyway, if the lawyer and the client believe that the lawyer is a professional who's making judgment and there's an art to lawyering, it's not a science, then the clients would feel more, would understand better if the outcome doesn't turn out the way they hoped. And, you know, you can't always, as a client, you can always blame the judge. So that's okay. That's part of what why I get paid the big bucks. But I'm just saying that if we could go back to it being a profession, maybe everybody would get along a little better. And frankly, you wouldn't have to do the last bit of discovery. You say to the client, listen, I don't know what this guy's going to say. We have the documents, but I'm going to do the best I can. And anyway, but the other thing, I'll say one more thing, and that is that these cases are their clients' cases. These cases are not the lawyers' cases. And even though I'm very active in the litigation section and I believe in the jury trial at my core, it is important that lawyers understand, and I had this several times when I practiced. My client wanted to sell the case, just give the case away after one was there was been a threat, and another one, they just were nervous Nelly. And the punchline is, it's not my case as a lawyer, it's the client's case. And so if they want to settle, they should. And that's why ADR and plea bargaining, well, that's criminal is a little different, but ADR is an important thing to talk about with the client, because clients want control. And when they are in that courtroom, there is no control. The client has the least control of any human being in the courtroom.
Judge Atlas, it's Tom Dunn. We have a question from the participants. The question is, with the Supreme Court deciding only about 60 cases per term, are the circuit and district courts getting enough guidance from the top on the important legal questions?
It varies. I'm glad that the Supreme Court is actually taking on some of these patent cases and technical cases, because that is our bread and butter, not patent alone, but the technical cases with the complicated statutes. That's our bread and butter. And so they're doing a little bit, but you're right. No, the Supreme Court isn't giving us enough guidance, but what's happening is the circuit is doing that more. So the circuit is really the last word by and large. I saw in the chat, and I can't go back. There was a question about,
Yeah, Judge Locke asked a question. Judge Locke, you want to ask your question?
anyway.
Yeah, okay. Sorry about that. I'm a little slow with technology. I was just curious to what you do to handle cases where you have clearly unequal talents.
Oh, that was it. Yes, yes. That is a great question, and it is a really difficult one. And I think you said in criminal, and then you also said civil. Let's talk about criminal first. In criminal, you have a baseline of ineffective assistance of counsel and the due process clause. And so in federal court, as you know, we can ask questions, and judges sometimes do take over the questioning because we don't need to get reelected. But it is not appropriate to lawyer the case affirmatively. There are times when, and this is a very nuanced thing, and we could debate in another setting whether this is a real distinction, but I'm going for it, Judge, because I sit up there in a criminal case and I don't take over the questioning most of the time. I rarely, but in front of the jury. But there are times when I will call a break and I will ask the defense attorney who is really messing up or is asleep at the wheel. I will say, I mean, literally bend over from the bench at the sidebar and say to him, what are you thinking? What is your strategy? Because, you know, as a judge, you don't know what would hurt, what questions would hurt. So I can't get into it with the witnesses but with the government, I can be a little rougher. But the point is that you just try to protect the defendant from ineffective assistance of counsel in a criminal case. And when the government is overreaching, I could just say, I don't answer that. I mean, I just issue objections myself. And that's not that popular. I don't do it very often. But early on, and I say this about Jimmy Leo and most of the assistants now, they have a conscience. It was like when I was in the office. It wasn't about getting a notch on your belt when you prosecuted. It was about prosecuting a crime and then getting a punishment that was appropriate for that crime if you proved or the guy admitted being guilty. And so if you're at trial, low blows, so I think it's up to the judge to stop the questioning if it's overreach. And that's another weakness, you know what I mean? It's the flip side of what Judge Locke you're asking. In the civil side, it's hard. Most civil cases are decided on the papers. And one of the big changes I mentioned was there's so many motions. Everybody has to file a motion to dismiss even when it's worthless. And or you just want to find out what the other side thinks. It's just a strategy. It used to be mediation was a strategy. Now it's motions. But anyway, in the pretrial conference, you can, as a judge of a civil case, if you do it yourself, you can say to both sides, tell me about this case. Yeah, I've read the pleadings, but there's nothing in the pleadings by and large in most cases. And the weak attorneys really come in the littler cases, the cases of discrimination where, they're weaker lawyers sometimes, not always, or tort cases. And so I'll say, well, what have you got? What have you got? Talk to me. And then I ask questions of the parties in order to, if they're thinking, alert them to what I think the important issues are, or what may be the important issues. And yes, I happen to be curious because I'm an auditory learner and it's a really great thing for me to hear. But the fact is, sometimes I'm hoping it's stimulating thinking. So that can sometimes equalize a little bit without, I don't think it's overstepping myself. But judicial ethicists might vary. So I hope that.
Judge Atlas, kind of touching on dealing with an ineffective defense attorney. Do you see possibly in the future that there might be some onus on prosecutors to start to reel it in a little bit? I can tell you the worst thing for me is going up against a bad lawyer, because then I feel like I'm doing both jobs. I'm doing their job and my job because I was in appeals, so I know how it works. I want a good, clean case. So, but what are your thoughts? I mean, is that something?
Well, you know how you do a reverse proffer, or you do, I mean, maybe you do proffers. Hopefully the lawyers come. Yes. I've actually heard of cases where the defense lawyers didn't show up at the proffer. I wasn't there and I don't know what was going on behind the scenes, but that scares me. Anyway, but I basically think if you're going to get this case all the way to trial, then just stay in your lane, try a fair case, and you do the best. That's your job, because you represent the taxpayer. You represent us. On the other hand, the reverse proffer for those of you civil, as I understand it, and maybe Jimmy, you want to explain, but basically the government tells the defense what they've got. Right?
Yes, we'll sit down with the defendant and his attorney and we'll show them our case. Right. And usually it's because we've got you need to plead guilty. This is not the way you want to go.
And it's up to the defense attorney to poke holes in that if possible. But, a lot depends on the facts. And, but the answer is no, I don't think that the government's going to have to carry both burdens. But I think that Brady matters. And my experience was that when you have task forces that are multi-jurisdictional, meaning state, county constable and feds, maybe 2 types of feds. You know, you got some drug or whatever gang task force. Sometimes the state or one of the agencies is not forthright.
Right.
Then what happens? So I have been saying to them that the government has to go ask everybody and produce everything. And I'm actually trying to create cover for the government because sometimes somebody's hiding something. You know, it's not often.
Right. I think Janet Brown had a question.
Yes, hi everyone. Thanks so much, and thanks to Tufts for this terrific series. So I left the practice of law. I teach and direct the judicial clerkship program at Northwestern Law School in Chicago. I hope this question wasn't asked at the beginning. I was a bit tardy, but I've been following some of the adaptations the courts have been making as a result of the pandemic, and I'm curious to know from your own perspective, Judge, whether there are any technological or other changes the courts have made in this past year that you think should continue once this is behind us, either from an efficiency perspective or an access to justice perspective.
Yes, and I think that it likely will continue. I think that many judges love having their pretrial conferences by Zoom or by phone. I guess I should turn around that comment to say, do lawyers much prefer Zoom, or are you willing to do by telephone also? But that, I'll leave that as a rhetorical question. The other thing I think that will stay is for the isolated, for certain witnesses that really can't travel, will do in a trial. I think more judges will actually allow the video link live testimony if the lawyers can live with it. There are issues about the security of it, though, in the sense of, is the witness being coached by somebody in the background? How do you protect from, you know, adverse influences like that? The other thing is, so video, I mean, virtual conferences and things I think will stay. Not every time, but a lot. We did so much of it so effectively. My law clerks during the pandemic worked in 2 different locations, and I was all over the place. And I talked to them every, you know, whenever I needed to. But I think that the hard part about virtual work is you can't develop the close relationships. You can't drop in with a cup of coffee. I can't go sit in their office with my feet up and say, okay, what are you working on? You know, I can do it by phone, but or whatever, but you get the point. So I don't want it to be too virtual.
I think that's one of the things that everyone's probably struggling with and trying to figure out what that balance is going to look like going forward.
Yeah. I'm part of this task force I'm on has generated that debate because the older people want FaceTime, face to face. They want to sit in the room. They want to have their whole team together, you know, where people can interrupt each other and stuff like that. Look at documents, pour over, you know, and the younger ones don't know what they're missing. They say, no, virtual's fine, you know, and they don't even know what it's like to actually have a partner run into their office and say, I've got this emergency, come with me, and then take them to the client's office. I mean, anyway, the point is, I'm hoping it'll be a hybrid, but there will be meaningful stuff going on in offices.
So Amy, why don't we stop the recording now and we just open up the questions to the group and everyone can chime in.